This
moment, but
conference will now be recorded.
there we go. We've got also a neat audience, combination of contractors throughout Wisconsin, and then colleagues and executives from around the country. So it's a national group, which hopefully is as anticipatory of this presentation as we are here locally. I've also got Amalia Schrader and Diane Bohacek from my office, and then I know Jeff Gakey and Julie Walsh from Wisconsin and other markets are on the call as well. As we mentioned, we are coming here from Milwaukee. I am Jonathan Kowalski, the Executive Director of our Milwaukee, as you know, is the home to the DNC and the champion Milwaukee Bucks. But then again, I guess as we've learned in the past few months, neither of those things are true anymore, but we can maybe hope for the latter. So we're excited again to have you. Rob Driscoll is a shareholder with the Reinhardt Law Firm in their labor and employment practice. His practice covers a variety of litigation-related issues. He represents employers to help them, as he says, avoid disputes before they start, with an emphasis on discrimination, wage and hour issues, non-compete agreements, etc. With more than 10 years of experience, Rob is an accomplished attorney who takes the time to get to know his clients' needs and goals in order to provide effective legal solutions. He is here today to give us the ins and outs, some examples about social media and the NLRA. We will also have time at the end of the presentation for you to ask questions, specifically over to GoToMeeting. In the upper right corner, you'll see the little chat bubble. You can click that button. You can address questions throughout the presentation to Rob, to Amalia, to Diane, or I, and we can jump in and introduce those when appropriate as well. You also have Rob's contact information on your screen right now. If you have questions for him afterwards, he would be happy to have a conversation with you and see what the next steps might be as far as that goes. So without any further ado, I will introduce Rob Driscoll. I will put myself back on mute. You're all on mute right now. If something comes up and you would like to ask a question, you can manually unmute yourself. But Rob, the floor is yours. Take it away. Thank you.
Great. Thanks, Jonathan. Thanks for that nice introduction. And Diane and Amalia, thank you as well for all your help putting this together. And of course, thank you to our attendees for this presentation. As the title on your screen shows, this is about social media and the National Labor Relations Act. And I was telling the group here before we started, when I first started giving social media presentations about 10 years ago, I had to explain what a lot of social media was to people. Many people did not know what Twitter was, did not know what a tweet was. Facebook was a little bit more common, but still a lot of people had never used it before. I think that's changed a lot in the last 10 years. And so it's not so much that people don't understand what social media is, it's how the law applies to social media. And the good news, I guess, is that it's very similar legal principles that have gone back for decades. And social media is just a new way that people, employees, express themselves. And those principles get applied now to Facebook and Twitter and Instagram and TikTok and whatever else, the hundreds of other platforms that are out there. And so this presentation is going to focus mostly on the National Labor Relations Act and how that applies to unionized employers. But it's really important to remember, and a lot of non-union employers forget this, frankly, that the National Labor Relations Act also applies to them. It also applies to your non-union employees, say, working in your office. They have rights under the NLRA. And we'll talk about that. In fact, the bulk of the talk will be about those rights because they get complicated and then they affect how your collectively bargained employees, also how you interact with them as well. The other thing to remember too, as we get into this, before I get kind of deep into the law, just remember none of this is legal advice. You'll see as we go through examples, a lot of this is very fact specific. So it's not a bright line rule all the time that you can just apply. A lot of this is just kind of guidance for you. None of you are expected to be or should become experts on these issues. It's rather just an issue spot. And maybe before you take an action, stop, think, step back and say, maybe I need to talk to counsel about this before I do it to make sure that there's not a bigger problem coming down the line. And so even though we're talking about the NLRA mostly, in the background, there's other federal statutes and state statutes that you should just be aware of. I have them listed up on the screen here. Title VII of the Civil Rights Act. It's what everyone refers to when you say you can't discriminate based on race or color, religion, sex, or national origin. And that applies to all employers, union and non-union. The Age Discrimination in Employment Act is for employees, no discrimination against individuals who are 40 and over. The Americans with Disabilities Act, of course, against no discrimination against people with disabilities, and then state law applies a lot of times, and may cover actually more characteristics, more things that are protected. And to give everyone kind of a flavor of how difficult this can be, especially when you're dealing with a collective bargaining agreement, let me give you an example. I'll use the Fair Labor Standards Act, actually, which isn't up on the screen, but it governs overtime and wages. And you may have situations where your collective bargaining agreement, say, requires you to pay double time for work on holidays or on Sundays, or maybe double time for work over 50 hours in a week. None of that's required by the Fair Labor Standards Act. So if you fail to follow that, it wouldn't be a violation of the Fair Labor Standards Act, it'd be a violation of your contract with your employees. On the other hand, there may be things that are in your collective bargaining agreement that the union has agreed to that is violative, that violates the Fair Labor Standards Act or wage laws. And an example is particular to Wisconsin. Generally speaking, you can bargain with the union to have clothes changing clothes at the beginning day be not compensable. You don't have to pay for that time. Wisconsin law doesn't allow you to do that. And so you could have it in your collective bargaining agreement and still run afoul. You could still have employees filing challenges. So it's really important to get your head around all the different legal obligations that apply here, both the NLRA, discrimination statutes, federal, state, and of course your collective bargaining agreement. So to give another example of maybe how state laws apply to social media in particular, I'm going to use Wisconsin here. Wisconsin has a specific statute protecting social media and email accounts. Essentially, what it says is you as an employer cannot require an employee to turn over their passwords to an email account, to their Facebook account, Instagram, whatever the case may be, as a condition of employment, which means you can't say, in order to be hired, you have to turn this over, or to a current employee, you have to turn it over or we're going to fire you. There's a very specific guarantee in the Wisconsin state statutes. Now, there are some exceptions to that built into the statute. I think probably many of you are thinking, well, what about if someone engages in misconduct and we're investigating? And you're right, that's an exception that's built in. If you have, if you're doing an employment investigation into misconduct, a violation of an applicable law, work rules, violation of work rules, or maybe just an unauthorized transfer of confidential business information, at that point, you can require employees to turn over or allow you to view their social media or email accounts. It's just you have to have a reasonable belief that there's misconduct by that employee and a reasonable belief that somehow their social media or emails part of that, right? You can't just say, well, some petty cash went missing, so we want everyone to turn over your social media account. There has to be some sort of tie-in to getting that information from them. And so this is just one example for Wisconsin. Other states may have similar laws or more stringent laws or different things governing social media. What many of them have is also kind of what we know as common law invasion of privacy. So it's not a statute, it's a court-made rule that guarantees employee privacy. And typically speaking, how this applies to social media is there's been cases where employers have created fake Facebook accounts and used them to try and become friends with an employee in order to monitor that employee's behavior online. And that's been found to be an invasion of privacy. It's kind of getting access to what they're posting under false pretenses. Now, all of this stuff, there's other things you can, of course, do. This doesn't stop you from restricting access to a company Facebook or Twitter account. It doesn't stop you from prohibiting disclosure of trade secret information or really confidential information over social media. Doesn't stop you from disciplining an employee who steals that information. It's really just process related, but just keep it in mind and remember that if you're coming up with a situation involving social media and email accounts. Okay, so I mentioned before, of course, the National Labor Relations Act. I think everyone here is familiar with it. It's in the background of everything you do is, having a collective bargaining agreement. What I mentioned before about other employees who are not bargaining employees, who are not part of the union, is having rights under Section 7 of the National Labor Relations Act. And so when you hear people say Section 7 rights, this is what they're referring to. And it's a very specific guarantee. It gives employees, all employees, the right to engage in concerted activities for the purpose of collective bargaining on the one hand, or other mutual aid and protection. And it's really that mutual aid or protection in concerted activities that is really important for social media specifically. And what do those mean and how do those apply in social media? Because employees have this right, if you violate those rights, they have an unfair labor practice claim. And if someone was fired in violation of their rights, they have a claim for back wages and they have a claim to be reinstated. And you can go through this process with the NLRB where you're going to litigate those cases. And so it's usually about Section 7 rights specifically. So what does this mean? Let's unpack this a little bit. And I think the first word you see is concerted. You think of a concert. It's group activity. This is the right to protect group activity. And importantly, it's not just group activity itself, but it can be an individual person trying to get his or her coworkers to engage in group activity. So what the NLRB has said is that it's initiating or inducing or preparing for group action, or that has some relation to group action in the interest of employees. And so that's the hallmark of group action. It does not include what the board has called individual griping, even if the complaint, that gripe, was made in the presence of other employees. It's actually a fairly narrow exception, what a gripe is and what a group action is. We'll talk about that a little bit more, but that's the breakdown. So what the board has also said about it is that an employee's statement to a supervisor or manager must either bring a truly group complaint regarding a workplace issue to management's attention, or the circumstances must support an inference that in making the statement, the employee was seeking to initiate or prepare for group action. So again, it could be an individual employee coming to you to complain about something, or complaining about it to other employees, or even to a third party. But if they're trying to initiate some form of group action, it's going to be concerted activity and can be protected. So, I know those are kind of obscure legal concepts. So let's talk about it in a little bit more specificity here. So electronic communications certainly can be subject to group concerted protected activity. Things on Facebook, things on Twitter. And I'll give you an example here from a board case from 2014 called Triple Play Sports Bar. In this case, the employee had gone to Facebook and typed out a post complaining about the employer's withholding of taxes from her paycheck. And she wrote, maybe someone should do the owners of Triple Play a favor and buy it from them. They can't even do the paperwork correctly. Now I owe money, WTF. And so she had that post, and under the post, people started commenting on it. Her coworkers started commenting on it. One said, something, I owe money too. A third employee said, I owe too, and then called the business owner an asshole, put that on there. And then the fourth employee liked one of those posts. If all of you are familiar with Facebook, when someone posts something, you can just hit that little thumbs up button to like the post. So that fourth employee, that's all that employee did, was just like the post, okay? And so the company's owners, they caught wind of these Facebook posts. Doesn't matter how, but they saw them, they found them. They didn't like them. They terminated a couple of the employees, including the employee who merely liked the post. And that employee brought a charge with the NLRB, and the board ruled in the employee's favor. It said merely liking that post was a form of concerted activity because it's in the context of all of her coworkers complaining about something related to their employment. And so that's how minor or small a concerted activity can be. It's just merely liking a Facebook post and do it. I suppose I haven't seen a case like this, but I suppose in the context of Twitter, retweeting someone else's post complaining about, withholding or something else could also be concerted activity, seen as that. And so you have to keep in mind, just even though it's a minor thing, it looks like it's probably concerted and maybe protected activity. In this case, the employee was fired, but even maintaining a rule or a policy related to social media that violates these rights could also be the subject of a board charge. You don't have to actually have had to have taken any action with it. You could be subject to an unfair labor practice charge because of that. So let's give some other examples just to kind of put some, make sure you see how this applies kind of in the real world. So these are examples of protected concerted activity. An employee posting complaints on social media about how much employees are paid. That's one. Another one, social media posts expressing concern about workplace safety when the group contained other employees. So that's an interesting case. Okay, so this had to do with a clothing retail shop, and one employee went to the owner of that shop and expressed some concerns about her safety working late at night. She was alone, there was no security. The other shops in the area, they closed early, closed I think at 7. This shop closed at 8. She wanted to close early. So actually the employer or the owner agreed, said that's fine. That message didn't get translated to the manager of the business, however. And when the employee left early for the night, the manager became upset and started saying things and yelling at people, things of that nature. And what happened then is the employee and one of her coworkers went on Facebook and started complaining about the manager. One said, "My manager is as immature as a person can be. The way she treats us is not okay." The employee then said, "I'm bringing a California workers' rights book to work. My mom works for a law firm that specializes in labor law, and boy, you will be surprised by all the crap that's going on that's in violation." And so the employer saw these posts, the manager did, fired these employees. What the board said, this is protected concerted activity. They were complaining about safety, that's protected. Complaining about violations that they found, that's protected. And it was in the context of a group complaint on Facebook, so it's concerted. Another example, an individual attempt to enforce a provision of a CBA. So what happened here was that you had a collective bargaining agreement that said that it shall not be a violation of this agreement where employees refuse to operate such an equipment unless such refusal is unjustified. It had to do with safety. An employee who doesn't feel safe operating equipment can refuse to can operate. That's what happened. An employee refused to operate equipment by himself, no other employees involved. And what the court said in this case is that's group activity. That's group activity because it concerns their collective bargaining rights. Something that's in the collective bargaining agreement makes it group activity. Another example about concerning safety. He had an employer that had electrical linemen, and one of them went on a Facebook page. It's called, I never heard of it before. It's called Line Junk, and the board opinion actually said it was one of the most popular Facebook pages followed in this, the electrical industry. And the employee went on and started complaining about safety, about the employer and the record of safety and things that he thought were unsafe. And the board found that this online discussion, even though it was in a group that wasn't related solely to the employer, was protected activity. The employer, acted poorly or violated the law by disciplining the employee for this. And in that case, the employer actually, in the hearing, brought a bunch of employees to the hearing that said, we don't agree with all these statements. We don't think that this is unsafe. We don't sign on to this. And the board said that doesn't matter. Even if this employee was the only one complaining about this and no one else agreed with him, the fact that it's in the context of trying to engage group activity is all that's mattered. all that matters. If he's completely unsuccessful and he really is the only one that ever signs on to these kind of complaints, it doesn't matter, because the purpose of it was to try to get group action involved in this. The last one is one that's maybe the most surprising, and it's about engaging the assistance of a third party in a labor dispute. And that can be protected activity depending on how it's done. And so in this case, there was a security guards union, and they had a contract with the United States Marshal Service to provide security for the Marshal Service in their building. And the union, the vice president of the union worked for this company and had been receiving complaints from his members about payroll practices and other things. And he didn't get the satisfaction that he thought he should from the employer. So what he did was he wrote a letter to the Marshal Service complaining about these issues and telling the Marshal Service that the employer was treating its employees poorly through payroll practices and whatnot. And he was fired for that. But what the board said is that that letter was protected because he was trying to engage the assistance of a third party in a labor dispute, an ongoing labor dispute. It was clearly concerted. It clearly affected all these employees. It's clearly protected activity, involved their terms of employment. That was protected activity, even though it went to a third party. It would not have been protected if he had said something along the lines of, to the Marshal Service, and the security services we're providing are terrible. We're doing an inadequate job. This employer is just, they just don't know what they're doing, how to protect people. That's different. It's a line that kind of the board draws. You're disparaging the product and the service and not just merely complaining about, the way employees are treated. And so it's a tough line sometimes to follow or to recognize, but it's there. But you can't just assume that just because they went to a third party, it's unprotected, because it could very well be protected. So what are some examples then? I mentioned griping before, of griping that is not protected activity. There's actually not too many cases finding that something is a gripe, because a lot of times, even if you could see someone's just complaining about something, if it involves other employees, it becomes concerted. One case had to do with an employee who refused to do a rust proofing job for first day of work, or first time he was assigned to this particular job. He claimed it was unsafe, and the board said, well, this is just individual. No one else is complaining about it. You're not trying to solve a problem for everyone else. This has to do with you. So that's individual gripe. Have to be careful about this in today's world and the post COVID-19 world, because safety is of course on everyone's mind. And so someone refusing to come into work because they think it's unsafe due to the transmission of the disease may be found to be concerted, but you have to walk a very fine line with that. Another example is that an employee who complained about something, there was another employee involved, but the complaint was really solely about the one employee. It was motivated by his concerns, not about the other employee, not about employees in general. Again, it's not concerted at that point. It's merely a gripe. Again, it's a very limited exception. So if you're tempted to try to rely on it to say that this is not considered protective activity, always a good job to kind of step back, think about it, maybe talk to counsel before you do anything, because again, it can be a difficult exception to prove. And you might be better off looking at other aspects of what the employee has been doing if they've been engaging in misconduct. Okay. So I mentioned earlier those various statutes, employment statutes like the Civil Rights Act. They were a big deal because there is some types of conduct that is never protected, whether it's on social media or otherwise. Illegal or violent activity, not protected. A breach of a contract is not protected. And as I mentioned, unjustified disparagement of products and services, not protected. But there was a whole range of behavior that the board had found was protected, but that other laws, other federal laws, had said the employer had to do something about because it was illegal behavior. So one very kind of, I call it an infamous case from the board, and it's not too old, 5 or 6 years. There was a picket line. The employees were on strike, and one of the employees who was on strike on the picket line started using racial slurs at some, I think they were the strike breakers, the replacement workers, started using some pretty bad racial slurs, yelling them out, screaming them out to people. And the employer took action, fired the employee, right? And why would they do that? Well, because Title VII of the Civil Rights Act, prohibits hostile work environments based on race, and prohibits discrimination based on race. And so any employer in that situation would have done probably the same thing, and rightfully so. But the board found that the activity was protected because the employee was on a picket line, and ordered the employee to be reinstated to the job. So you can imagine as an employer sitting there, right, the difficult spot that you were being put in by this. On the one hand, the Civil Rights Act, the Equal Employment Opportunity Commission was telling you, you got to do something about this. You got to fire the person, discipline. On the other hand, the board, the National Labor Relations Board, is telling you, you can't. It's protected activity. What do you do? So that hopefully has been resolved just actually in the past couple of weeks. And the board, which has kind of new members since that decision I mentioned, has issued kind of a new framework. And this is going to apply generally, it's going to apply to social media, it's going to apply to everything else. And so it's kind of a burden shifting thing where you have to show the employee engaged in the activity, that the employer knew about that activity, and then that activity caused the dismissal. And then the employer can show that they would have taken their action regardless of it. So in the picketing example, yeah, the employee's picketing was protected. The employer knew of the activity, obviously, is on a picket line. And picketing, or at least what he was doing while picketing, was part of the cause, part of the reason. But the employer could very likely show that it would have taken the action even if picketing was never in the scene, even if this just happened on the floor of the workshop, right? That they don't tolerate racist behavior, and would have fired the person anyway. And so it takes employers out of that that hard spot that the board had been causing. So we talked about all this, right? Giving you some examples of social media and how it applies in the social media context, in the Facebook and Twitter and all of that. But those are just the background principles. Let's talk kind of specifically about how you might see this in form of policies, because it involves policies as well. So firing someone for Section 7 activity could very well be a violation. But as I mentioned earlier, even just maintaining a policy or a rule and never acting on it could also be a violation of that. And so, you think of it, you might have like 3 categories of rules. A rule that explicitly, let's say, told employees they can't talk about their wages with one another. Clear violation of Section 7. Just it's what we would call facially invalid. You violated Section 7 by having that rule. But there are a lot of other rules that are neutral, and don't necessarily on their face violate Section 7. So you might have a social media policy that talks about civility on social media. And that's not a standard, that's not a facial violation. But what the board for many years had done was just to kind of apply some very cryptic standard to say whether it would reasonably chill an employee's Section 7 rights to have that rule. Lawyers had no idea what this meant in any particular circumstance. You had a lot of conflicting decisions, and you had a lot of rules that seemed like very no-brainers, again, like civility rules or act professionally, that were being found to violate Section 7. So a few years ago, the board issued a new decision kind of changing this up and giving a lot more guidance and leeway in that. And so when you're looking at your policies, your existing ones or developing another one, you have to keep this decision in mind. It's called the Bowen decision. And what it said is like, look, there are 3 different ways you could have this neutral rule, right? You could have one that an employee may look at and think, well, I don't think I can engage in this activity because of it. I'm not sure, it's just unknown. You could have a rule that's promulgated in response to union activity. Again, neutral, completely neutral. but it's brought about because a union member had done something to advance his bargaining rights. That's going to be unlawful. Or you could have a neutral rule that you apply to someone's protected activity. That would be unlawful as well. But there's this third category I mentioned where it's not really clear. It's not really a violation, but someone might see it as such. So what do you do with those rules? So what the board said was, look, we're gonna look at these kind of as a reasonable person would, and we're gonna put rules into three categories that are generally okay, that deserve a little bit more scrutiny, and some that are just, facially invalid. So one of the big ones, so let's just kind of go through a couple of these. One of the big ones I mentioned was civility, right? Civility rules were out 5-6 years ago. You couldn't have them. Now the board is saying, yeah, that's okay. You can tell your employees they have to be civil with one another. They have to be civil when they're on Facebook. They have to do all that. Now, if it's in the context of complaining about their wages to a manager, there might be a little bit more leeway there. You might not be able to say, well, you use a swear word, so therefore, you violated the civility rule. But you can maintain the general rule in behavior. All these other rules as well. So no photography, no recording. Under the old standard, those were out. Last 3 years, though, they're okay to have. There might be exceptions. For example, maybe an employee uses the cell phone to record like a really dangerous work condition. That might be okay. You may not be able to discipline someone for that. But generally, prohibiting no photography and no recording is okay. And you can see some of these other ones that are generally going to be found lawful in most situations. Now, there are some that are in the middle. Again, a few of them here where the board does do a balancing test and kind of balances what your legitimate justification is. Criticism of the employer, right? Sometimes that's okay. You can bar it, sometimes not, because it might be in the context of a labor dispute. Restricting speech to the media or other third parties. So this is an important one, and you should look at your policies over this one, because in general, you're allowed to say to employees, you cannot represent the company. You can't talk to the press and hold yourself out as a representative of the company. That's fine. But you couldn't maintain a rule that just says you can't talk to the media or you can't post on Facebook or anything like that, because they would have a right to do that as long as they're not holding themselves out as a representative of the company. So these take a little bit of balancing and a little bit of review. Then finally, there's some rules that are just unlawful in general, even if they are neutral. You can't require employees not to talk about their wages or benefits or working conditions. The board is very sensitive to those rules, even if they're kind of written in a very neutral manner. Or you can't prohibit them from joining outside organizations, because that, of course, could apply to a union, and that could be an issue for Section 7. Look. We always recommend get your handbook. Look at your handbook, see if there's any that you think may be a problem, talk to counsel about it. You might want to revise it, because, again, merely having the rule on your books can be a violation. And even if you think it's neutral and you apply it against Section 7 activity, that could be a violation as well. So there's still a lot of landmines, but this new framework actually gives you a lot more leeway than was the case just even 5 or 6 years ago. Okay, so let's talk about a little bit some examples of these policies. So in a recent case, the G&E real estate management case, they had a very long social media policy, and it talked about what they couldn't do. They couldn't represent the company, telling them everything about it, and then actually went into their personal Facebook use, personal social media use, and said, okay, when you're using your personal account, don't use the company phone number. Say that you do not represent the company. You have to say that. Don't disclose confidential information, and otherwise don't violate company policy. So, for example, don't engage in harassment of coworkers on your Facebook account. And the board found that this was okay, because it clearly delineated the difference between the company's interests and the employer and the employee's personal accounts. They couldn't use the employer account for a broad set of things, but on their personal account they could, just with some very minor restrictions. So the board found that to be okay. Another example, the Bemis case. This was a little bit tougher of a case. The board came down and found it to be okay, but it was a little closer. What the Bemis company had was a social media policy that said to be respectful and professional, don't disclose proprietary information, safeguard Bemis's reputation, and don't create a hostile work environment. It wasn't as clear in this case, though, that this applied mostly to personal accounts. And so it made it a little bit closer of a decision. But the board said that, look, in its entirety, the rule is pretty clear that this has to do with the company's justifications to maintain its confidentiality and its reputation and its policies involving harassment. And that a reasonable employee would look at this and say, that's fine. That doesn't stop me from complaining about the company on my personal account. It doesn't stop me from engaging in protected activity for those types of things. I think the lesson from this case is the more explanation you can give, the more context you have in your rule, the more clearly you're saying what's okay on the personal side versus the company side is going to be better for you. It's going to give you a better chance to show that the context is supporting what you're trying to do. So what about unlawful social media policies? These are a little bit tougher. This one in the Postal Service shows you just how narrow the line is. Basically, they had one section of their policy, social media, that was okay. It said, don't disclose confidential information. And the board said, yeah, that's fine. You can say that. You have a compelling interest to provide your duty to protect your confidential information. But they had another one called their acceptable use policy that applied very broadly. It applied to the use of their network, to use of their company email, but even like to personal blogs and email and social media account. And it prohibited them from disclosing any Postal Service information that is not otherwise public without authorized management approval. And what the board said here is, look, you have very broad policy applied to personal. The definition of Postal Service information that's not otherwise public can include a lot of things, wage information from the employee that's otherwise protected. And you can't get around it by saying, well, management can approve it, so that's fine. It's not enough. And so the board found that was an unlawful policy. They had a conduct clause, very broadly saying, you can't perform any act that may discredit, defame, libel, abuse, embarrass, tarnish, present a bad image of, or portray in a false light the Postal Service, its personnel, business partners, or customers. And the board's concern here was, if they wanted to go to the media and talk about the media and talk about the struggles they're having with the Postal Service over their wages, that could very reasonably be seen to discredit the Postal Service or embarrass them or tarnish their reputation. And so it could discourage that type of activity. So it was, it's unlawful. Another one, this coastal industries, very quickly, most of you, maybe many of you have a policy barring cell phone use. In this case, the employer had that, but it didn't clarify that that didn't apply in break times and on lunch times. And that's kind of protected to be able to use that, use the cell phone when you're not working and you're outside of the working area. So again, having that broad policy ran afoul of the law. Specifically, and again, check your policies. This policy said the use of personal cell phones or other mobile devices is prohibited during working hours for personal use, including phone calls, texting, and downloading of web content. So, during working hours could very easily mean when they're on break or where they're in lunch, and that was too broad. Okay. One other area that, as an employer, you can kind of get tripped up is in, we'll call it surveillance. Many of you are probably aware of kind of the acronym TIPS about how you train your supervisors, not to threaten, not to interrogate, not to surveil, not to solicit grievances, which applies in the election context especially, but also kind of generally when supervisors are interacting with employers. So surveillance is a big thing, especially on social media, right? It makes it very easy to figure out what your employees are doing. And so in this case called Advanced Pure Foods, it's a board case, it's not too old. The board said that the employer had violated the act by surveilling an employee's Facebook account. So what happened here was that 2 employees had discussed a union campaign on their local radio station. The management caught wind of the discussion, and as a result of that, started digging around in the 2 employees' Facebook accounts, trying to find more information about it. And what the board said was that this was unlawful surveillance because the employer was taking an intentional action in response to union activity. So that they heard about the union activity, they went to Facebook and tried to find out more information about it. And so here's what the board said. Although carried out with more modern methods, this is no different than the curious supervisor who, upon hearing that there would be union activity at a roadside park or a local tavern, takes a ride over there to see what he or she could see. And so what you have is kind of, again, a very thin line here. If a management employee is simply friends with an employee, is on their Facebook page and sees this information, that's not surveillance. But if they go there with the intent to find it, or as a result of hearing some other information about it, it could be surveillance and could violate the act. You do not have a duty to monitor your employees' social media accounts, and as you can tell, if you take it upon yourself to do so, or to go about digging in their social media accounts, you could run afoul of the law, even where no one's terminated, even where no one's disciplined, merely by surveilling someone through it. So it's very easy to do. I know a lot of employers look at social media accounts in the context of hiring, but there are pitfalls, especially in the union context, where there's union activity and there's rights protected by Section 7 of the Act. So just a kind of a brief word about collective bargaining then. It's in ways, it's a very small portion of how social media applies in the context of the NLRA, because it's a simple one. Social media, having a policy governing it, is a mandatory subject of bargaining. The same as with wages, the same as with benefits, safety, work schedule, overtime, all of that. It falls in with there as something that you need to bargain over. Your CBAs may have a management's rights clause, right now, that gives you the ability to promulgate a policy, reasonable policy, or that waives the union's right to object to you making a social media policy. But you got to be very careful with that. Waiver has to be clear and unmistakable, and your policy has to be pretty specific in giving you that authority to promulgate this policy. So you have to treat it like any other policy that you may bargain with the union over, like a drug and alcohol policy, et cetera. If your past practice, if your CBA generally gives you the right to kind of promulgate policies and put them in a handbook that apply to union members, this would fall under that as well. And so certainly you can do that, but just be careful about it if you're looking to start a social media policy or change one that you already have. Maybe you have one that's part of the CBA right now. If you're going to change it, it's going to be part of the bargaining process, just like any of the other provisions. Once you have that policy, of course, termination is subject to all your just cause provisions. It's subject to your grievance provisions and perhaps to arbitration if it gets there. It's no different than any other conduct policy in that regard. So just remember that just because something violates the policy doesn't mean you can terminate. You have to follow your other policies leading up to that. Okay, so one of the big issues here, and I've mentioned it a couple times, has to do with sexual harassment and hostile work environment. This applies to all of you as employers under Title VII. Many of your collective bargaining agreements probably have a statement in there saying that the employer, the company won't discriminate based on sex or race or anything like that. So it's both a legal principle and it's a contractual one, and it applies just as much on social media and Facebook. This is one of those situations where, again, the principles are very much the same, but the application becomes difficult. Makes it a little bit harder to navigate these. And I'm going to talk kind of in the context of sexual harassment because it's been obviously in the news the past few years, but all of this applies equally to any other sort of harassment, racial harassment, religious harassment, and national origin harassment, all of those things. It's just in sexual harassment is where you see it the most. And frankly, on social media, it becomes very easy for an employee to engage in this behavior, either because they think they're anonymous or because they're not in the workplace, so someone's not watching over them as they're typing out, or they're used to engaging in this kind of behavior with friends and don't realize who else could be watching. All those things apply and make this a more difficult issue now than it was 10, 15 years ago. So what is harassment? First of all, it's unwelcome speech. The definition of unwelcome is that employee does not invite or solicit the conduct, and it's based on sex or gender. Verbal, physical, visual, all of those things could be sexual harassment. A picture that's posted to Facebook, a statement made, a statement made of some kind, all those things could potentially be harassing in one aspect or another. And it doesn't have to come from a supervisor. Two employees on the same level, co-workers, one can harass the other and create a hostile work environment for that other person. Now, in order to be a legal liability, in order to violate your obligations under the law or maybe under your collective bargaining agreement, it has to be severe or pervasive enough to create a hostile environment. So, one action usually is not enough, but if it's severe enough, it might, some sort of sexual assault, that's hostile work environment. Or it could just be a series of discriminatory comments made repeatedly over a span of years that kind of go uncorrected. That could be harassment as well. So what are some examples of this? Sexually related jokes or comments, requests for sexual favors, emailing explicit images can certainly be harassment. And then, verbal cues as well, physical cues as well. All of these things, maybe by themselves in cases are not enough, but they can kind of build up to that. That's why it's so important. That's why you have the social media policy that prohibits things like this, maybe references your harassment policy, and to try and stop these things before they get so serious that you've engaged in a violation. So we're not talking just about a supervisor who conditions, a promotion or a raise on some sort of sexual favor or something like that. It could just be comments made. Maybe no one gets fired, maybe no one loses a job, promotion, but it's such a difficult environment that it can be actionable in and of itself. Again, severe or pervasive enough, it's a kind of a limitation on it. But you want to, if you catch wind of something that could eventually lead to this, you want to take action soon, because it can protect the company before it gets to the point where you're talking about liability. So how do you gauge this? How do you, as an employer, what do you do? It's subjective. You look at it subjectively. Was the employee actually offended? And then objectively too, would a reasonable person have been offended by something? Was it unwelcome, or was it two people that were engaged in the same conduct going back and forth with one another? Doesn't necessarily matter what the harasser was thinking they were doing. So even if they didn't intend to discriminate, it still could be. And often, as I tell employers and tell people, in the workplace, a lot of stuff that you say that you think could be harmless or is just a joke and no ill intent could be viewed very differently by your boss, your coworkers, or kind of most importantly for our purposes, a jury. And so this type, the type of behavior, that's why, as an employment attorney, and it's just as much in the union setting, you're looking to try and stop it before it gets, bad enough to be a violation of law. And this applies on your social media accounts too. So you may, as an employer, again, you have no duty to monitor these things. But if a supervisor is friends with someone that they're supervising, and they see a really bad, harassing comment to one of their coworkers, they may have a duty to do something about that, to go to HR to correct the behavior, or if they're made aware of it involving coworkers, because it could create a hostile work environment, even though it's on Facebook, even though it's on Twitter, or whatever else may be the case. If I haven't said it already, I say it again. Your social media policy should bar harassing conduct. If it doesn't, it should at least refer to a harassment and your harassment policy, and so that people are very clear that just because they're at home on their social media page doesn't mean they can talk to a coworker in a certain way that would be considered a hostile work environment. Okay, I think as all of you know, and as I mentioned before, the CBA is going to govern all this, even when you have your policy in place. And this all applies even to your non-bargained employees. If you have office employees that are not part of the bargaining unit, Section 7 rights apply just as much to them and to what they're posting. And of course, they're protected as well and bound by the sexual harassment rules just as much as your bargained employer. So, it should be very clear as you have policies. Maybe you have two sets of policies, one for your bargaining unit members, one for the regular employees, the non-bargaining unit members, but they should both address these issues. You should be sure that both of them kind of comply with many of these principles that we talked to today. It's a very tedious process. It's very cumbersome. There's a lot of very thin lines to be drawn, but so talk to your counsel about it. Work together to make sure that your policies, one, that you have them, and two, that they're going to stand a fair chance of being upheld should you ever be challenged. Okay, just some other things to remember, and then I'll take some questions. So get your questions ready. Hopefully you have some. One common misperception, especially in today's world, is that employees have a right to free speech that is protected by their employers. That's not true as a general matter. The First Amendment does not apply to most employers. It may be to government employers, but to private sector employers, it doesn't apply in general. And so someone doesn't have a First Amendment right to say certain things that the employer might not like. Their rights are kind of spelled out what we talked about with Section 7 and otherwise in their federal statute. So employers are, generally speaking, free to discipline or terminate employees who say something that they don't like, maybe take a political stance that the employer doesn't like. You have to be careful with that, though, for a lot of reasons, kind of practically in terms of morale. You may cause your yourself to look like an employer that people of a certain political stance don't want to work for. Or other employees think that they aren't supported by the employer, or they have to walk on eggshells and they don't like that and so don't want to work there anymore. There could be certain things that walk a very fine line with what's kind of political and not protected, or subject to protected characteristics. For example, religion. Someone who engages in a religious march of some kind that has a kind of a political component to it about a certain political position. Well, if you terminate them for that march, it could be seen as religious discrimination. And so you might have a battle over that. But generally speaking, the First Amendment doesn't apply. You just have to be very careful about how you're interacting with your employees in these settings. We talked about policies, a lot of this, really important to have. Training, very important to have. You're doing that now. Your supervisor should do it as well so that they can apply the policies in an efficient manner, because consistent enforcement, documentation, all of these things are key. You can have a perfect policy, but if you're all over the board on how it's being enforced, that can open you up to potential for liability. Same applies on social media. How you're applying it to people's actions on social media and how you're documenting it is really important as well. So that's kind of the lay of the land. It's a very complex area, as you can tell. This fortunately just kind of scratches the surface of everything that's there. It's a constantly shifting surface because the NLR, National Labor Relations Board, as many of you may know, is appointed by the president and typically shifts as administration shifts. So a lot of the things that I was talking about opening things up is the result of President Trump having appointed additional members. Whereas President Obama had members that took a different stance and came out a different way. And unlike the courts, they don't feel bound to previous decisions. And so it's always changing. It makes it a very difficult area to keep up in. But so always be in contact with your counsel and work to have your policies in as good a shape as you can and to enforce them in a consistent manner. So that's all I have for the main presentation. Jonathan, I didn't know if you wanted to have a few words and then maybe give people a chance to type in with questions or whatnot.
Thanks, Rob. Yeah, you can load any questions you might have in the chat, or unmute yourself, and we'll kind of take those in order. I wanted to thank you, Rob, for this really detailed overview as to the very uh, gray area that this lives in, right? Not only with just employer-employee relations, but then adding the NLRA and other CBA-related components on top of it. So thank you for that. One of the general questions that comes up, and again, this covers a lot of different areas as we lead into an election and we're dealing with different social justice situations now when it comes to personal Facebook use or personal social media accounts. And you did talk about if a supervisor or a manager is casually friends with someone, they see something, it's not surveillance for the purpose of without the intent to surveil. If someone posts something on their personal page, for example, wearing a company logoed merchandise shirt or next to a company truck or wearing a company hard hat that has what could be viewed as harassing opinion. I'm trying to be generic here, but I know some of the employers on the line and execs on the line have had situations like this. Is this just a time for an employer to have a conversation with an employee? Is this something more significant than that? How would you recommend the first step in a situation like that where an employer casually observes a social media post that could create some conflict or harassment in the workplace?
Yeah, so certainly, I think it depends on what the harassing behavior is that you're seeing. I think the first thing you're going to be doing is getting, to the extent you have human resources department or someone that's tasked with human resources, they're going to be involved right away. Supervisors should know that. They're probably not going to take action on their own. They're going to go to the HR department and you're going to work together with them because it could be a known issue already. Or it could be something that's happened previously that this particular supervisor didn't know about. And so you're probably going to have then some sort of investigation into what the behavior is. Let's look at the post first. Maybe it was an overreaction. Maybe it wasn't as bad as we thought. But if it was, it was targeted at a coworker especially, then you're probably going to be talking to the coworker and seeing what's going on. They're kind of like the victim of this. Let's talk to them. Is there something else going on in the background we should know about? And then you're going to talk to the person that put it on there as well and figure out what that is, what the situation was, and go from there. There's a million different iterations of what could happen. So is that kind of where you're going with that, Jonathan, or is there something maybe else?
A little bit. One of my, maybe if it was maybe broader to say, as an employer, what we don't want to see is, for some reason, someone else views that post, sees the person decked out in Kowalski Industries swag, and then can make it could be a dramatic leap, but maybe not, that says, oh, well, this person who's a foreman or whatever for Kowalski Industries represents the company, and they're holding up a Black Lives Matter sign, or the opposite. Do I have any right to say, hey, employee, you're well within your rights to have opinions, but can you do so not in front of my truck, or can you do so not wearing our stuff? Again, it's trying to differentiate between actions of an individual versus actions representative of an organization. And they could go well beyond that, right? To be more harassing, but even if it's just voicing an opinion with your stuff around.
Yeah, so if it's truly just like a Black Lives Matter protest, or maybe an anti-lockdown protest, right? Really not implicating the employer at all, not about their wages, their working conditions, and they have a company logo on or hat on or something like that. Generally speaking, that's not going to be protected, wearing the company logo. And you probably have the ability to say, look, you can't do that. You can't go to these, we're not telling you not go protest for Black Lives Matter or go to the anti-lockdown protest or whatever the case may be, but you can't do it with a company logo. It gets trickier though if it's like a union protest of some kind, of certainly picketing, or they're trying to talk to the media about how they're being treated. Then it's probably going to be protected activity. I think you can tell employees on social media, don't put company logos on and don't use company logos. But if they were to use it in the context of posts complaining about some of these protected activities, that's probably going to be found to be protected itself as using that logo.
Got it. That's helpful. We have a question on the chat from Hope Voigt. Rob, I don't know if, can you see that question directly?
Yes, I just pulled it up.
Okay.
Yeah, let me read it off to everyone here. What are the best practices for investigating the legitimacy of posts? Does employer have the burden of investigation, or if we are presented with evidence and we act based on face value of that evidence? That's a great question. If you have a post that looks suspicious, and you're not sure whether it's a real post or whether it's a coworker or whatnot, you certainly should investigate it. I don't know that there's an obligation, but if for some reason it turned out later to have been legitimate, but you had investigated and found no evidence of that, and it was a good faith investigation, you're in a much better place to defend yourself otherwise. You see this a lot with anonymous complaints, right? People that make anonymous tips and whatnot about how they're being treated. Well, at some point you need to talk to that person and figure out who it is, because anonymity is important, but as an employer, in order to rectify the situation, you need to know who the victim is and what their situation is, and so that you can tell the person who's being accused who it is, so they can respond, right, to make it a fair investigation. So that's why one of these things that we tell people, especially with sexual harassment, and it's a tough conversation, don't get me wrong, is you may have someone that comes to you and say, I've been harassed, I want to tell you about it, but don't tell anyone else. Don't move it up the line. And your HR people especially need to know they can't guarantee that. They need to say, look, I want you to tell me about this, but I can't guarantee. We might need to take some action if this is justified. We have policies in place, and I'm glad you came to me, but they can't guarantee that you're not going to investigate it. And I think the same thing applies with a post that you may think is on its face invalid. If you have an indication that it is invalid, it's made by a troublemaker who's not an employee or anything like that, you have no control over, investigate it, figure that out to the extent you reasonably can, and document that as well.
Rob, I had a recent question and I thought I'd wait for this program to pick your brain a little bit. So doesn't really have to do with social media, but in the current state of affairs where everyone, we're obligated to wear face masks in certain situations. And typically the policies have been, we'll provide one or you can bring your own, and people have their preference. What if that face mask is politically or religiously deemed inappropriate by the employer and or a project owner, right? So, decide, I guess, Black Lives Matter, Blue Lives Matter, All Lives Matter, whichever side you want to pick. I wear it onto a job site and the owner of the job site says, nope, you're not wearing it. What's my duty as the employer?
Yeah, so it's a very complex area as well. There's a whole jurisprudence cases about, say, union insignia. The general breakdown is, maybe you can bar them with customer-facing positions where it's going to affect the business and whatnot, but not otherwise. So there's that side of it. If it's say it's a religious statement of some kind, you always have to be worried about whether you're applying something equally, that you're not targeting, say, someone who has wants to wear a face mask with like a Muslim symbol on it, but you're not allowing it, but it's a cross you allow, or vice versa. So you have to do it from a kind of an equal standpoint there. But a political message in general, by itself, is not going to be protected. This goes to the free speech thing. I think for morale reasons and for consistency reasons, if you're going to take the position that someone can't wear a Blue Lives Matter mask, that someone shouldn't be able to wear a Black Lives Matter mask as well. That's just from consistency. Some employers may take an opposite position because they feel really strongly about one or the other, but there might be some practical consequences to that in terms of, again, morale, maybe bad publicity, ticketing, things of that nature. So it's other than what I mentioned about the consistency and the protected characteristics of the union logo, it's really it's not as much of a legal decision as it is a practical and, kind of say cultural one.
Okay, thanks.
Yeah, frankly, Diane, when you started the question, I thought you were going to ask about people that didn't want to wear masks at all when you had a masking policy. So that's a new one.
Yeah, we've got that too.
That's a difficult one. A lot of employers are struggling with that, and that's a it's a CBA issue if it violates an anti-disability discrimination policy, but it's also an ADA, Americans with Disabilities Act issue.
Right.
Does anyone else
have any other questions? Oh, sorry, John.
Oh, you're good. Same message. Anyone else have questions to either put on the chat or again, feel free to unmute yourself and shout them out. Rob, if while we're waiting, if you want to roll back to the first slide, it's got your contact info on it. If people do have specifics they want to follow up with you on, that's where they can find you.
Yeah, great. There you go. And Jonathan, I think looks like you put in the chat message before about the slides will be made available to everyone later today if they want a copy of them as well.
Yep. And we will have this available for recording for you to either review again or share with those who are interested. It doesn't look, Rob, like we have anything else. So before we break, I wanted to let our guests know that if they go to pmsmca.com, they can learn about our upcoming events, including our Sporting Clay event scheduled for September 17th. It's safe, it's social distance, it's outdoors. It's a great way to connect with people in an environment that I think, frankly, we've been lacking this year. So by all means, go there to register. But again, I wanted to thank Rob Driscoll from Reinhardt for the very insightful, thoughtful presentation today with a lot of content. There's probably going to be follow-up from some, but hopefully this gets you all on a right path as to how to deal with this ever-changing landscape. So thanks again, Rob, and thanks all who joined us on the call today.
Thank you, Jonathan. Thank you, Diane, Amalia, and everyone who's here. I really appreciate the opportunity.
Everyone have a great rest of the week, good weekend, and a good balance of the summer. Thanks, everyone.
Bye-bye.
I was trying to leave and it won't let me leave.